Ladies and gentlemen of the jury, an attorney at law, when retained by another, is entitled to fair and reasonable compensation for the professional services rendered. There is no fixed standard by which the value of the services of an attorney can be determined. His value and reasonable price necessarily vary with the magnitude and and importance of the particular case, the degree of responsibility attaching to the work performed, the difficulty of the matters involved, the time consumed, and the benefits derived. In ascertaining the value of such services, you will exercise your sound discretion and judgment and allow such reasonable amount as you believe constitutes a just and fair compensation for the services rendered not to exceed the sum of $3,000. In determining the value of the services rendered, you may take into consideration the fact that at the time of undertaking the work, the attorneys bound themselves to make no change or charge for their services if they failed to secure beneficial results. The fact that these services were to be rendered on a contingent fee basis, which means that no charge was to be made unless beneficial results were obtained for the defendant, should be considered by you in determining the value of the services. It is customary for attorneys to charge more when they undertake to render professional services on a contingent fee basis, because under such a contract, no charge can be made unless beneficial results are obtained, no matter how much actual work may have been performed. You are instructed that the mere fact, if it be a fact, that the litigation did not result to such advantage to defendant as he may have hoped it would, does not preclude the right of plaintiffs to recover in this action. If the defendant employed the plaintiffs to prosecute the suit in question, the plaintiffs are entitled to be paid for their services. The plaintiff filed this action, gentlemen of the jury, in the district court of this county and alleged that on the 18th day of June 1929, the defendant, in consideration of the annual premium set forth therein, delivered its policy of life insurance to Thomas M. Doolittle, deceased. That the face of the policy was $6,000, with a provision, however, that in the event of death from an accident, the defendant agreed to increase the amount payable to $12,000. That on the 5th day of January 1958, said deceased Thomas Doolittle died by reason of an accident. That the plaintiff furnished the defendant with proof of death, affidavits, certificates, and statements of parties having knowledge or information concerning the same, and made demand upon the company for the payment of the total sum of $12,000. That on or about the 15th day of March 1958, the defendant paid the plaintiff $6,000 by reason of the execution of the policy, with the understanding, however, that said payment would not preclude the plaintiff from presenting a claim against the defendant for the sum of $6,000. That the defendant refused to make further payments and plaintiff prays judgment for $6,000, payment of which she claims is due under the terms of the policy. The defendant answered and denied generally the allegations of the petition, and admitted that it was engaged in the life insurance business in the state of Alabama and issued the policy of life insurance on the 18th day of June 1926 to the plaintiff herein, and admits that proof of death and other data in the form of affidavits, certificates, and statements were furnished by the plaintiff to the defendant, but alleges that said statements are insufficient to establish that the deceased died as the result of an accident, and denies that the plaintiff is entitled to recover any amount and asks judgment for its costs. If the issue in this case is the constitutionality of the statutory provision made for taking the property, its constitutionality seems clear. If, as I assume to be the case, the issue is the constitutional sufficiency of the statutory 10-day notice by publication of the hearing to assess the compensation for the land taken, I consider such a provision to be within the constitutional discretion of the lawmaking body of the state. In weighing the due process of condemnation procedure, some reasonable balance must be struck between the needs of the public to acquire the property and the opportunity for a hearing as to the compensation to be paid for the property. just compensation is constitutionally necessary. Is it?
It's good. It's kind of rushy.
Where'd you get that?